I might just start with Emmanuel. Having heard James's critique, and I understand it's meant in the most constructive way, it can be said the white paper, neglects to engage with the realities of the shipping industry, including the multiplicity of the actors that James has mentioned, and also the sort of the streamlined, expedited dispute settlement mechanisms that he's alluded to in his presentation.
Yes, there is one James has not addressed, which I've read in his written comments, which I like very much, is that the current situation is a race to the bottom. And of course, it's cheaper to abuse seafarers and not to respect environmental norms. It's cheaper and more efficient probably to bribe ministers to obtain contracts. All that is true, and some players in the industry compete by doing that. And we see that there is a strong resistance to that attitude, and we see how it works internationally in the fields of environment, in the field of corruption or embezzlement, influence peddling. And if you take that latter example to see how things evolve, it takes time. But some states want to do the right thing in the field of corruption, not engaging in corruption, even not domestically, but even in foreign countries. The US took the lead. They had the FCPA. And then, of course, that was a disadvantage for their companies. We cannot corrupt anyone, others do, so it's unfair. So they sponsored the international, the OECD convention, which to create plain level field. And now it's the UN convention, and it's pretty much accepted worldwide. Now, whatever the practices are, is a different matter, but there is recognition, and the customers are buying it. So there is incentive. It can be the banks. I was very much encouraged by Robin's presentation. It can be the customers. Customers prefer to buy something a bit more expensive because it's not produced by children in certain unregulated jurisdiction. And I think the same thing can exist for human rights at sea. You may want to pay a little more for a product which has not been transported by people who would abuse seafarers, right? So I think the dynamic is complex. It takes time. In the case of, if you take the difference between today and when the US started in adopting the FCPA, that's 20 years. Now, I think things are going faster these days. And in this field, I think it will take less than that. But one point which James is making, which I very much appreciate, is the diversity of the situation. Currently, we have different norms, different jurisdictions, and it's a great pleasure for some of us, including myself, to think in choice of law terms. What is the applicable law to that aspect, and what is the applicable law there? Which forum can we go to, and so on. So here, I think that's an approach which is not appropriate. What I'm suggesting is an approach which couples simple norms. I will respect, it can be even written in 3 lines, I will respect the Human Rights Convention. And that's the key thing. And I will arbitrate with anyone saying I don't in this forum. And the norm applicable may not be any intricate applicable law which is selected through unpredictable choice of law rules. It would be the human rights standards. But an arbitrator will be able to couple the violation with money or other remedies. The remedies question is another topic, but with remedies which will be enforceable through the New York Convention. That's the offer. And it does not mean to replace all the ways to solve disputes between different players in the field, which will remain complicated. If the tortfeasor is insured or the violator of human rights is insured, fine, they can sue their insurance company. They can deal with that segment in their own, wherever they want. But the key will be to create sufficient incentive for the major players to adopt some rule to do the right thing, and then put pressure on the others to reconstitute a competition which is fair and on an equal footing. So I think that's the dynamic we are talking about.
James, would you like to react to that? Do you think that people will pay for kind of this tailored, sort of streamlined stream of dispute resolution?
Depends who you mean by people.
Sorry, I mean, I've been imprecise. I mean, the actors within the shipping industry.
Well, I think that Robin and Emmanuel are absolutely right, that it's all about making the incentives work. And I personally have huge admiration for things like the responsible ship recycling scheme and its cousin. They really ought to be in the same bed of the Poseidon principles. But I don't want to get lost in the detail of that sort of thing. But I do think that there is a point here which is about bandwidth. And you can also express it as fragmentation. I mean, just on the environmental side, even if you just go down ship recycling, not only have you effectively got 4 international legal regimes, one of which isn't in force, but you've also got a ship recycling transparency initiative, cheek by jowl with the recycling responsible ship recycling scheme, which is not, as I say, under the same roof of the Poseidon principles, even though it's doing the same thing. It's banks trying to get owners of ships to do the right thing by writing it into their loan agreements. And I think that's absolutely the way to go, or at least a way to go. Obviously, one would like an international regulatory regime which made all of this sort of thing beyond argument, but and you might be lucky. The IMO does produce some good environmental initiatives, but it's made its life easier on that score by some of the provisions in Marpol, which effectively allow it to legislate. But the difference here is that you're starting from a different place in terms of the international regime. So yes, I think incentives, for example, from the banking sector could be very useful. That said, it's worth bearing in mind that unfortunately, since the financial crash of 2008, the European banking system has lost what was the lion's share of the loan book in the shipping industry, and it's now firmly based in the Far East. And at the moment, as far as I know, few, if any, quite possibly no Chinese lenders who are now really among the big players in the market have signed up. So that is a worry, in the sense that it's fine for all us Europeans and North Americans to think that this is a very good thing, but actually the powerhouse now is firmly located in Asia. And it's to people in that part of the world that we need to be speaking. Which is a long way of saying that I agree, and it's all very, I mean, it really is very interesting and very difficult. And I think the fact we're all talking about it is a good start.
Thank you, James. Robin, I saw you nodding vigorously, I thought, to Emmanuel's remarks. Did they resonate with you?
Yeah, and I think both what James and Emmanuel have said is right in line with our thinking. Honestly, we'd prefer to see something at the LMA level, so the Loan Market Association level, come across on human rights. And as part of the Dutch banking agreement, we actually asked for that. So I think all of you, maybe some of the listeners here, could help us by also petitioning for that with the Loan Markets Association, because we'd really like to see things like the UN guiding principles, and therefore what it means in terms of a grievance or arbitration mechanism, be simply embedded in all loan agreements. We think that should be the standard. We don't think it should be the thing that defines sustainability per se. I think what defines sustainability should be a higher standard than that, rather than that as a base standard. To speak to what James was saying earlier about Poseidon principles and the responsible ship recycling standards. Yeah, the conversations are happening, by the way, between both groups. So don't so you can have some confidence that we see the challenges with having multiple regimes in place as well. We in a lot of ways suffer from that because there's so much going on at the European level and so many different obligations over the coming years that we're going to have to live up to and need to really plan for and implement well. In order for this all to come together, but I think it begins with these being seen as common standards, not the upper standard, but the base standard for what we're expecting of companies, and that means everybody working together, since a lot of the basically even parties like governments, they're often the biggest buyer within a country. And therefore, this is within their supply chain as well. So it should be part of their contractual agreements with others also. But anyway, I don't want to rant too long on that.
No ranting at all. Very valuable insights, I think, which everyone greatly appreciates. I'm just conscious of time, and we want to respect the 30 minutes that's been allocated to general Q&A. So I just wanted to wrap up just one question on the issue of obviously transparency. It's obviously a hallmark of international arbitration that they're generally confidential or and private and held in private. And as Manuel has outlined, there's I guess some tension between wishing to secure transparency, perhaps analogous to the investment treaty regime, and particularly given the stakes involved, and at the same time protecting, where appropriate, the victims. James, did I understand your presentation to connote that you had some concerns about the role of transparency in these types of disputes?
My concern isn't really with transparency in the disputes per se. There's a lot to be said for transparency. It is in itself a good thing. It may even be a necessity in the context of employment rights. I have heard, although I don't know because I'm not an employment or a US lawyer, that in US law some arbitration agreements have been struck down where employment rights were being arbitrated, precisely because there was a lack of openness and transparency. My point, and it may be that there's quite a difficult circle that needs to be squared here. My point is more that if you are trying to get buy-in from an industry which is used to a relatively low-key, and I say relatively very carefully, low-cost arbitration system, which is also confidential, broadly speaking, it's going to be harder to get buy-in if you make it more expensive, more open, and staffed by people who don't necessarily know much about shipping. That's not an attractive package to put together. And so it's just in the context of getting industry consensus that I think some thought needs to be given to the extent to which it is legally permissible to have a confidential process and be desirable, and where the compromises might be drawn. And I know that confidentiality is capable of being exaggerated, and the institutions led by the ICC are rather moving away from keeping their awards confidential. But confidential is where it's at, as at 2020. And I think, given the innate conservatism of the shipping industry, it would be a mistake simply to say, oh, well, we must all be transparent, hurrah, because hurrah is not the reaction you will get from a lot of players in the shipping industry.
Thank you, James. Emmanuel, any comments on that? Do you think the appropriate setting, having regard to James' concern, would be to have confidentiality as the default setting from which the parties by agreement could depart?
That transparency for human rights abuses is the right form of arbitration. To me, confidentiality is not of the essence of arbitration. It's a feature of many arbitrations, but it's not of the essence of arbitration. Consent is of the essence of arbitration, not confidentiality. It's just a feature. So I understand for shipping disputes, I understand why confidentiality is fine, and that's fine. For human rights abuses, I think transparency is essential. But even for big players, they can be turned into publicity. PR. We are doing the right thing. Buy my products. They are brought to Europe through healthy channels, not through human rights abusers. It's exactly the same PR when you say buy my products, a bit more expensive, but it's not done by children somewhere in the world. So I think transparency. There is no way a system can work if it's not to redress human rights abuses if it's not public and fully transparent. But in any event, it's not necessarily a bad thing for what we want to achieve, and it may not be a bad thing for those who want to do the right thing and want that to be known. They can turn that to their advantage. It's like a Total funding big projects to help children somewhere in the world, right? Or depollute certain areas or what. Doing the right thing can be a good PR, a good publicity vector these days, and maybe this is one which is becoming urgent.
Thank you, Manuel. James, I think would like to just add one point.
Well, without dissenting really from anything that Emmanuel has said, I think it's quite important going forward to pick one's vocabulary with care. Because of course it's one thing to say, well, human rights abuses must not be shrouded in secrecy. But the word abuse is very emotive, and it is not, perhaps it is, I'm not a human rights lawyer, a term of art. Something may contravene human rights legislation without, in popular terms, amounting to an abuse. And to say to the shipping industry, we want your human rights abuses to be dealt with in this open forum over here, is just not a way to garner support. There are plenty of human rights violations which fall well short of an abuse. And of course, as soon as you say we are going to allow the arbitration of human rights, you are going to have the full spectrum from what might be quite technical but important abuses, for example, a failure to investigate properly, right through to fully fledged abuses. And I just think the vocabulary needs to be tempered.
Well, thank you, James. Robin, any last minute-long contributions just to cap off that very interesting discussion?
Yeah, no, I think, first of all, transparency should be the default position, and then we can see for certain circumstances where there might be more confidentiality needed. But I agree with James as well. If we think about the outcome that we're seeking in terms of effective remedy, whatever brings the party to the tables is the path we should pursue. So if it is tempered language that does that, I think fantastic. I do strongly believe that it's really about the outcome more than the path to getting there. So for me, that's highly important given everything that we've been seeing happening in the sector.